We know from the 4 Supreme Court cases that we discussed earlier, or 5, that 12-year-olds are different from 20-year-olds. And so when we are fashioning our orders and making decisions, they should be developmentally appropriate. We should use simple language. We should give clear instructions, use concise terms and conditions tailored to meet the goals of probation and the characteristics of the child. So in my courtroom, I do a lot of exchange between me and the young person before me. A few months ago, I wrote something and I asked my son to read it, and it was supposed to be written for young people. And so he read it and he wrote back, and I think I've told Judge Ashby and Judge, one of our other friends this joke, and I'm not sure it's a compliment or not, but at any rate, my son said, "Oh, this is really well done. It's written in the voice of like a 4th grader," which I thought that was pretty good. Being a lawyer and a judge for all this time, I'm usually prone to writing in legalese, which I was able to not do that in the document. So, but that is what we need to be able to do, to come down to the level of the child, and that's not a demeaning statement, but to come down to the level of the child and write in ways in which they can understand. And hopefully when you do that, the parents understand it as well, and they can then go back and help the young person understand what the judge has said. So when we're in court, we should go slowly. We should repeat the things that we're ordering the child to do. The judge should talk about next steps. Let the child know what is the expectation between today and the next time they come to court, and what they will need to do in order to successfully get out from under the supervision of the court, because we all know that that's what young people want to do. Young people, it's not enough that they understand what we're doing and why, but it's also important for judicial officers for how they treat young people. It's not just about how you talk to the youth, but it's about what is adolescent development that judges need to take into account in responding. So we want judges to use the bench card and the resources provided to help them consider adolescent development as they make decisions along all the stages of the case. So again, court orders, their language, their content needs to be consistent and simple enough for the young person to understand, and it makes it easier for compliance. So during the pre-style stages, a judge can develop a relationship with a child and convey a sense of fairness by asking age-appropriate questions and making some supportive and affirmative comments like, "Thank you for being here. I like the way you speak loud and clear. Your lawyer has asked me for a continuance of your case so that they can investigate and meet with you to prepare. Is that what you want? What is the best way for you to get in touch with your lawyer? Does the next court date work for you and your mom, dad, or your family? What do you think will happen if you are not at court on the next day and you're not on time?" So basically trying to engage the young people in the process and have them know that you are trying to pay attention to some of their needs. I remember when I first went on the bench, one of the questions was about setting probation reviews, and should you do it before school? Should you do it after school? And what about if the mom works? And what about if the mom gets off at 3 and we could set it at 3:30 and that would help? Having judges be willing to do that, which I still think in the conversations that I have with a lot of my colleagues, that's even still difficult to do. But when we look at what the cases talk about, again, I keep going back to the cases, but when we look at what those cases have said, I think all those things are things that we should be trying to do. I want to particularly just say that there are a lot of places around the country that are developing tools, developing processes that respond to those Supreme Court decisions. There is one that I want to mention because I think it is important for all of us around the country, and it relates to the Miranda warning. So remember in the JDB case, it was about Miranda warnings. And so the King County, Washington, the sheriff's office, not the court, not the prosecutor, but the sheriff's office, in response to hearing about those cases and what should be done, they have modified the Miranda warnings for young people in their jurisdiction. And so if you remember the Miranda warnings, just think about what they say. But this is how Kent County changed King County changed a couple of them. I don't have all of them, but here are a couple of. So the first one says, you have the right to remain silent. That means you don't have to say anything. 2, it's okay if you don't want to talk to me. 3, if you want to talk to me, I can tell the juvenile court or adult court judge and probation what you tell me if you talk. 4, you have the right to talk to a free lawyer right now. That free lawyer works for you and is available at any time, even late at night. That lawyer does not tell anyone what you tell them. That free lawyer helps you decide if it's a good idea to answer questions. That free lawyer can be with you if you want to talk with me. So just a few examples of how changing the language might make a difference in the Miranda warnings. So now I want to go briefly to the stages of the court process. And so the first one is the initial appearance. And generally at that appearance, the key question is about whether or not the child is going to be detained or not. And so when we are making those decisions, it is important for us to recognize all of the information that's come out of the research around detention. Detention is harmful. That's the point we want to make. Detention is harmful. And so we should use it only in those cases where we believe it is necessary to ensure court appearance and to protect the public. If we believe the child is going to come back to court and we believe that the child does not pose a threat to public safety, we should not detain the child. Because we know that more than half of the youth who are arraigned do not ever come back to court. And we know that unnecessary institutional confinement, it leads to recidivism. And it's even if it's less than 2 days, if it's just 1 or 2 days, there are harmful effects of being detained. It's traumatic. It exposes the youth to negative influences, and it has unintended consequences of youth identifying as an offender. So the court-ordered conditions of supervision should focus on supporting pro-social development, as Judge Aspie said in her last segment, since that is the most effective tool for reducing recidivism. We know that for LGBTQ, GNC youth, that they are detained more frequently for status offenses, warrants, and probation violations. And they are detained at twice the rate of their heterosexual gender-conforming peers, twice the rate. Youth who are detained, especially girls, youth with mental health issues, and youth who identify as LGBTQ, GNC are at higher risk of physical and sexual assault in detention. And these risks are substantially higher in adult correctional facilities. It's bad enough if they're in a youth detention facility, but if we put them in adult, it's even more traumatic. We know that the next slide, for example, shows that almost 18,000 youth were detained in any given night in 2013. And most of them were for nonviolent offenses, about 65%. And the vast majority of them were youth of color, 71%. So that's why paying attention to the racial and ethnic disparities is important. As it relates to transfer hearings, so there's been a lot of study as it relates to transfer hearings. I can't remember the year that Florida really started. I credit Florida with this huge rush to transfer young people to adult courts. And now that that has occurred for several years, there is some research and evidence that that really doesn't work. And I can recall at the time people were saying, we don't think it's going to work, but now we have some proof that it doesn't work. What we do know that when we transfer kids to adult court, it typically increases the rate of violence among transferred youth. While the evidence is insufficient to determine the effect of transfer laws and policies on levels of violent crime in the overall juvenile court population. But on the basis of the findings, there was a task force that recommended against laws or policies facilitating the transfer of juveniles to adult criminal justice system for the purpose of reducing violence. It just doesn't work, and it makes things worse. The review provides sufficient evidence that the transfer of youth to the adult criminal justice system results in greater subsequent crime. They become more violent, and so therefore transferring juveniles to the adult system is counterproductive as a strategy for preventing and reducing violence. So when we send them, again, summary, when we send them to the adult facility, we are interrupting all of the things that we know that really are good for young people and help them to be adults. We interrupt their connection to their community, their school, their family, in many instances, services that they need, mental health, substance abuse. So at the adjudication, okay. So at the adjudication stage, again, I think what we will see in more in courts, I'm hoping that what we will see in courts is that as attorneys are representing their clients, they will incorporate all that we learned from the Supreme Court cases and come before judges making arguments using the language and the research from those cases to help judges. And so making sure that, again, procedure fairness, that the child is proved guilty beyond a reasonable doubt. That's part of the process, and to hold people accountable for doing that. Making sure the young person has an opportunity to present their side of the case, that they have a meaningful opportunity to interact with their attorney, so that when we come to adjudication, that can be a fair process as well. At the disposition hearing, for anybody who feels like juvenile court isn't adversarial, and sometimes I've said that myself, but you only have to look at the statistics to know that's not true. So we are unique in the world. Again, the United States incarcerated 2 times more youth than the next highest nation. In the US, it's 94.68% per 100,000. The next highest nation is Cyprus, which is 46.5 per 100,000. We quite often want to say we do it better in the United States. I would be interested in finding out how it's done in Cyprus, so that the percentage of youth who are interacting with the court is, we're twice that much. So we should try to figure out how to do a better job. What we know about incarcerating young people is that it is expensive. We know that community-based programming is cheaper and it's more effective. So why aren't we doing more to ensure that we have those resources available? And the defenders, the attorneys who are representing children, are key to pushing back on incarceration and pushing for better community alternatives. And it's my hope that the defenders will begin to do that in a much more consistent way and really challenge those of us who are on the bench to be mindful of what we're doing at every stage of the proceeding. This doesn't begin to address the hundreds of collateral consequences of having youth involved in the juvenile justice or the adult system in terms of their education, their housing, their employment, and their future success. So kids get in juvenile court, they get a record, they can't get into the Army, they can't get into college, they can't get scholarships. There are a myriad of collateral consequences that, as we're sitting on the bench every day making those decisions, we need to sort of have those mindful in our mind. Those kinds of things make it hard for a young person to be rehabilitated. If you have lost your housing, you can't get a job, it's hard to think about doing what's right. You're just thinking about survival, and sometimes that means getting caught up in things that we don't want them to be involved in. At the disposition hearing, so sentencing and probation hearings provide an opportunity for interaction between the judge, the child, and their parents. Again, listen to the child and look for topics that you as a judge and the child can discuss in a positive manner, recognizing challenges and offer support and practical solutions. So to the young person, is there something that I can help you do? What can you do? What can we do to get that first first clean drug screen if substance abuse is a problem. What is happening in your life right now that you would like to change? What would you like to change about your school attendance? Better yet, what about school first? And I always engage young people around school because it was droned in my head as a young person that the only way to be successful is to get an education. And so I still believe that. And so first question is, are you enrolled in school? And then what grade are you in? And what kind of grades are you making? And what are your extracurricular activities? And what extracurricular activities would you like to be involved in? Why aren't you involved in those? Is there something that you need that you can't get that we might be able to help you get so that you can participate? Is it a uniform? Can we help you get that? Have you talked to your counselor, or has your counselor given you ideas about how you can control your emotions? So young people, I just get mad. When I get mad, I do this. So have you talked to someone about what you might do when you get mad and upset? And so have you heard about trying to count to 10 or walking away and coming back after a cooling off period? And then you can ask young people, so if they've had conversations with other people about how to behave, what suggestions have been given to them about how to deal with their behavior, you can ask them to tell you about that. And really follow up on what they say so they understand that you're not just asking as a matter of course, but you do want to know and you're concerned about how they are progressing. And then finally, I just want to mention again, Judge Ashby talked about it, the positive youth justice model. It doesn't restrict any youth justice interventions to any predefined or fixed set of practices. What it is it's a philosophy, and what it charges all of us to do is to really constantly look at what are we doing with young people, what are the opportunities for meaningfully engaging with them and providing opportunities for pro-social development, for them to learn to be engaged with their community, for them to learn about helping people who are less fortunate than them, all kinds of things that we want young people to grow up and be adults, and when they are adults, to how to engage in society. And so when they develop their plans, so the plan does, if a plan fit the model, but the question really is, how will the plan aid in the development of this adolescent into the adult we want him or her to become?
So before we end, I want to just touch base and talk a little bit about some of the post-dispositional hearings and how adolescent development research and some of the other discussion we've had may play a role in those hearings as well. So I'm not going to talk about all these areas, but the first I will discuss is appeals. First of all, as you can see from the U.S. Supreme Court cases that we've been discussing, adolescent development is playing a larger role in how appellate courts are looking at issues and how they may be relying upon research related to adolescent development to resolve issues. And it's important that the trial court record adequately reflect, one, what those issues are, how those issues were resolved at the trial court level, and why you resolved certain things the way that you did. One of the issues that I know has come up since Roper and that line of cases in the appellate courts is we've talked about there being no mandatory life without parole sentence for juveniles, but now you have courts wrestling with, well, are there equivalent sentences to life without parole? Even though it's not technically a life sentence, does it have the same consequence and result, and what should we do about those? So there are a number of issues related to adolescent development that are coming up and being litigated in the appellate courts. Also, in terms of review hearings and probation revocation hearings, I think there are a couple of things that are important to think about. One, with review hearings especially, you can either be developing or build upon the relationship that you have already established with the youth, and the review hearing can be a means of being supportive and encouraging for the youth, as opposed to sometimes what we tend to do is look at what the youth hasn't done and how we may be looking to consequence them for that. It's certainly at least as important, if not more important, at the review hearings to really acknowledge the things that they're doing well and to support them to continue those efforts. And in probation revocation hearings, we may want to start looking at the violations, especially technical violations, a little more closely and try and understand what is it about this youth that may be driving the noncompliance. Are there trauma issues that we need to address? Were the conditions that were imposed in the first place appropriate? And we can make modifications to our court orders to ensure that we are, again, helping to support the youth by recognizing their strengths, building upon those strengths so that they can exit from probation more successfully. And with the probation revocation hearings also, I think it's important, again, that we oftentimes think of how we're sanctioning a youth for noncompliance, but maybe we should start looking at things that we're doing which we can use as positive reinforcements that help them successfully complete their probation sentence. And in terms of conditions of confinement, certainly there are youth who need to be confined, but we have to recognize that when we are making that decision as to which youth need to be confined, what is it we are sentencing them to? What are the conditions of confinement that we're exposing them to? We've talked about peer influence. Well, certainly confining juveniles with a number of other delinquent juveniles may not be what we hope to accomplish because of the peer influence. But if we have to do that, make sure that the programming where we're sending the youth is such that they are also learning some very supportive, positive role modeling and also engaging with people, adults through those institutions who can encourage and support their pro-social development. And in Colorado, one instance, we have a statute that allows us to place a child in detention, not only because they are a risk to the community, but they're a risk to themselves. And I think we really need to look at, is detention and confinement really the appropriate approach to handling a child who is having significant issues that aren't a public safety consideration. I think instead we really need to look at the fact that if somebody is being a risk to themselves, that may be much more a treatment issue than it is a confinement issue, and we need to figure out how to appropriately respond to that. So I hope this has been helpful to you. I think Mary Ann's going to make some closing comments. We certainly encourage you to think about your own practice and decision making and how those things that you learned from Professor Kavanaugh may impact your decision making from this point forward.
Thank you so much for taking the time to explore how adolescent development principles impact our work in youth court, and especially how they impact the work of juvenile court judges in their decision-making. We hope that you'll take time to download the bench card and all of the resources that are linked on the same place where you found this website. Thank you on behalf of the National Juvenile Defender Center, our partners on our Judicial Council, the State Justice Institute, and the National Council of Juvenile and Family Court Judges. We hope this program will help you in your work to advance developmentally appropriate practices in youth court where you are. Thank you.